number of our great friends served on the Constitutional Review Committee this year. We weren't in favor of any more pregnant pig size amendments to the Florida Constitution, so helping the business community preserve some rationality in the Florida Constitution is a good friend of mine. Fred Karlinsky and I go back to 1990. Fred is a co-chair of the Greenberg-Traurig Insurance Regulatory and Transaction Practice. He is an expert, not just in Florida, but in insurance policy, statutes, and particularly regulation across the country. Fred travels. He puts more miles on planes than anybody I know, among other things. And we were commemorating the 9/11 event the other day. Fred was one of those people in the World Trade Towers that day. So thankfully he escaped, and thankfully he was there to help us protect our Constitution. But he will explain, and I take a minimalist view of how often we ought to change our Constitution. But Fred will explain a little bit about their process, what made its way onto the ballot that has survived court challenge so far. The ballots are being printed, if they haven't been already, Ryan. So in the next couple days, so if the courts haven't decided yet to throw something off the ballot, the chances are your supervisor is printing the language that the CRC, there are a couple of amendments that the legislature put on. So I'm proud to introduce a good friend of mine and an expert in all things Constitution and insurance policy. So Fred, thanks for joining us.
Thank you very much, Tom. And let me just say, as Tom pointed out, we've been friends for over 25 years now, and I am always proud to stand on any stage that Tom is on, and I'm always proud to stand with Tom on anything. And you all, as an association, should be fortunate that you have a leader like Tom with the principles and the Rolodex and the family that he does. So let's give a round of applause to Tom and the organization you've built. So let's talk a little bit about the CRC. I think the long story or the short story here is, for those of you that are familiar with doctors and the Hippocratic oath that they take, it's first do no harm. And I think that's what we hopefully did through this process. But let me tell you something, it was a very difficult process. You talk about basically running a legislative process with 37 people that don't know each other well in some cases, don't know each other at all in other cases, with only 5 professional paid staff. We had a lot of folks. I saw Chris Bailey earlier in the room. Folks like Chris from the governor's office and then from the House and Senate volunteered their time. But basically, we got together as a group for about 14 months and looked at changing the Constitution. And as Tom points out, one of the things that really resonated with the group, not initially, but after quite some time, was the notion that anything we did was going to be very permanent. The permanency of what we did ultimately did weigh heavy on our mind. And I think what the CRC will hopefully be remembered for, if we're remembered for anything, it's being remembered for the things that we did not do, some of which are very important to you. For example, Proposal 23 would have opened up the floodgates for any type of environmental litigation. That did not see the light of day. Proposal 51 would have very dangerously deregulated energy in the state of Florida. That also did not happen. Proposal 88 would have increased the causes of action for people in nursing homes, and that likewise did not happen. So while we go through this, and some of you may cringe a little, again, think about some of the things that did not happen. Think about the accident that we averted going through this process. But in any event, the Florida Constitution can be amended 5 ways. It can be amended by voter initiative. It can be amended by a constitutional convention, which will never happen. It can be amended by an action by the legislature of 60% or more. It can be amended by the Tax and Budget Reform Commission, which meets every other 10-year period that the CRC is not meeting, and then it can be amended by the CRC. Interestingly, and I know a lot of you have seen the court cases and the press and the challenges about log rolling and some of the other things that we supposedly did. Well, number one, I'll clue you in on a couple things. We basically used the same rules that they used in 77 and 97, 98. So we basically used the same rules. Number two, they bundled in 77, 78, 97, 98, just like we did. So I will not defend the bundling process. I'm not sure I agree with it, other than the fact that we understand that if there's 30 or 40 amendments out there, you'll have a significant amount of voter fatigue. But I would also say to you that the Tax and Budget Reform Commission and the CRC specifically do not have the same single subject obligation that the other three methodologies to change the Constitution have. And so while I won't defend the process, I will say that there's no question in my mind that it was a legal process to bundle these and that that was an okay thing to do. So as Tom pointed out, the CRC meets every 20 years. There was a joke about whether we should file an amendment to actually abolish the CRC. Frankly, I'm not sure that would have been a bad thing to do, because I think because of pregnant pigs and some of the other things that we've seen, we understand that this can be a pretty dangerous process. Florida is the only state that has that process. Again, we had 37 distinct individuals, 15 appointed by the governor, 15 appointed by the Senate president, 15 appointed by the Speaker of the House, 3 appointed by the Supreme Court Chief Justice, and then the Attorney General was automatically a member by virtue of her position. I will tell you that the temperature in the room went down greatly once the governor and the speaker started to get a little bit more on the same page on some legislative priorities. While that maybe should not have affected us, I think it did, and I think ultimately we wound up being a little bit more cohesive because of that. Our chair was Carlos Baruf. Carlos is, for those of you that don't know Carlos, I didn't know him well before this process. He's a builder out of Sarasota. Absolutely great guy. No legislative experience, by the way, which was interesting at times. There's a picture of us all. We met on the Senate floor, which was interesting. There's me at one of our public hearings. You can see how thrilled I look to be there. We'll talk about that in a minute. And this picture and this scene scared a lot of people, specifically Don Gates and Tom Lee, who were both on the commission with me. Seeing me up there on the rostrum really gave them anxiety, and probably rightfully so. So, as members of that commission, the 37 members, we had 15 public hearings throughout the state. The funny thing is, we all got appointed the beginning of March of last year during session. And so we started to have these public hearings around the state. And we had a number of legislators on our commission. Tom Lee was on it, Republican Lieutenant Governor candidate Jeanette Nunez, Pepe Diaz was on it. And so they were all really ticked off initially that we were having these meetings around the state and they weren't coming to them because they had other priorities. Until they ultimately went to one and heard what was going on there, they were like, thank you, we're never going to complain about this again. Because basically, we had about 6,000 people show up at these 15 meetings. We had more than 2,370 Floridians speak. And normally you'd say, hey, Fred, that's a pretty good thing. You should embrace that. And you know what? There were some people that came up that were passionate, that had real issues, that really wanted to get their point across. But a lot of the people were paid. A lot of them read from a script and were just trying to tell us what to do. A lot of them said we were imposters and we should be put in jail. I mean, it was pretty crazy. I will tell you that after Parkland, it got even more concerning because that issue, the gun issue, that the legislature ultimately took up, that we at some point in time were actually asked on the floor to take up, and we did not because I don't think it was our place to. That became a much more difficult issue, frankly, that we were never intending to deal with and ill-equipped to deal with. There were 103 filed commissioner proposals. So we actually had 103, for lack of a better term in legislative parlance, bills that we were dealing with. There were over 2,000 public proposals submitted. We also each individually had a CRC email. We probably got 200 emails on that a day. I probably fielded 50 phone calls from people a day. I don't think there was a day during this process, once we got to a serious point in it, where I didn't have multiple meetings with people on the CRC. We had 10 substantive committees. Those were committees like Finance and Tax, which I chaired, General Provisions, which I was on, and then 2 procedural committees. We had Rules and Administration, and then we had Style and Drafting, which ultimately was the committee that bundled the proposals. Ultimately, we had 8 final recommendations for the 2018 election ballot. We spent more than a year dealing with this process. Also, I would note to you that for the first time since that process has been put in place, the CRC has, you will have to get 60% on the ballot. 60% of the people voting will have to vote for any of the amendments to make them ultimately become law. So that is a high hurdle. Even if something is not controversial, I think the view is that that is going to be a tough thing to do, especially without some of the advertising that is typically involved in this process. And we'll talk a little bit about advertising in just a minute. The other thing I'd say about bundling, I did mention earlier that they did bundle in 77, 78, and 97, and 98. The 68 Constitution, the rewrite of our Constitution, which is about 30,000 words, the Constitution that we operate under today, actually was passed by the voters in 3 amendments, so only 3 amendments. So there is a precedent to doing what we did. But there are multiple amendments, as I mentioned, that have made it on the ballot. The first 5 actually did not come from the CRC, and I just want to preview those to you as well because they will be on the ballot. They've been vetted. There's no current challenges to them, so they will be on the ballot. And as Tom and Ryan pointed out, we're really getting close to D-Day, where ballots will be going out. So even if there is a challenge that has not been ruled on, that language will be on the ballot. It may not count. It may get invalidated if it does pass, but it will be likely on the ballot just because of the calendar. So Amendment 1, which was sponsored by the legislature, increases the homestead exemption possibility from 100,000 up to 125,000 with the exception of for school board purposes. Amendment 2 permanently retains provisions that are currently in effect which limit tax assessment increases to specified non-homestead real property, again, except for school district. That also was done by the legislature. Those 2 are on the ballot. The third amendment was done by a voter initiative. Voters in Charge. It's a voter control of gambling in Florida. Interestingly enough, I've not seen any money spent on that yet. I'm sure there will be at some point in time. The next amendment, Amendment 4, deals with the restoration of rights for felons as it relates to voting and some other things, as you all know, because you've seen it in multiple publications and a number of folks have done exposés, if you will, on it. Florida is one of the few states that does not automatically restore felon right to vote after they have served their time or done their penance to society. And so now we have a process where those folks need to go before the cabinet to do that. This would, in effect, this amendment would change that. It would not apply to murder or sexual offenses. In those cases, you'd still have to go before the cabinet to get those rights restored. There's been about $4 million raised for this. And so I don't know that that's enough to get this passed. And I think there's going to be certain people that will have some trepidation. This proposal was also a proposal that was proposed by Senator Joyner and Senator Smith, who were both, former Senator Joyner and Senator Smith, who were both on the CRC with us as well, but they did not move forward because it already made it on the ballot through this voter initiative. Amendment 5, similar to the last initiative, I actually sponsored Amendment 5 at the CRC, and I withdrew that once the legislature passed that. This is seemingly one of the amendments that should pass. It seems to have a lot of support. That amendment, Amendment 5, would require a 2/3 or supermajority by the House and the Senate to increase any taxes or fees or to create any new taxes or fees in the state of Florida by the legislature. So that to me is pretty good legislation. I would hope that that actually does pass or a pretty good amendment. Amendment 6, this one's going to be very interesting, and this one will be on the ballot because it's been vetted now by It was thrown out by the lower court, then ultimately the Supreme Court said, you're good. And so this is definitely going to be this is one of the ones that was challenged, will definitely be on the ballot. The crux of this is something called Marsy's Law, which creates certain rights for victims. The concern is that victims of crimes do not have the same rights sometimes as the accused. And so look to see this being probably the best funded amendment of all of the amendments out there. There's about 30 million raised to educate voters on Marsy's Law. And again, just like all the others, that would require a 60% vote. In addition, this amendment, which I co-sponsor and I believe is a very good amendment, also repeals something called the Chevron doctrine, which for those of you that deal in the administrative arena, this would remove the presumption that the administrative process effectively was correct, that it gives deference to the administrative agency. So this would remove that. In addition, this changes the mandatory retirement ages for judges from 70 to 75 years. For those of you that are asking or wondering, this would not apply to the current Supreme Court justices. So that process that we're going to go through will still take place. Amendment number 7, dealing with first responders and military survivor benefits along with public colleges and universities, is actually one of the amendments that is still being challenged and is right now, as we sit here today, on the 11th, so yesterday, it just got moved from the DCA back to the Supreme Court. This amendment, among other things, does give certain enhanced death benefits to military and first responders, survivors. It also requires a supermajority to increase or create any new taxes or fees at the university or college level, and it also establishes each state college system as a constitutional entity. I'm hopeful that that will ultimately get on the ballot and pass. Emory Gainey, who many of you know from the Attorney General's office, was really the main crafter of that proposal, and his heart was certainly in the right place on that. Amendment 8 is not on the ballot. That is the only one that we know for sure will not be on the ballot based on the challenges that have taken place. The Supreme Court has ruled against it. It did not surprise us. This bill would have been transformational in a lot of people's minds to the public school system in favor of charter schools, and this amendment will not be voted on in November. Among other things, part of the bundling issue was some people liked certain parts of it, other people did not. The term limits for school board, I think there was uniform agreement that should happen, but because in large part of the charter school language, that got bounced off of the ballot. Amendment 9, sorry Dave, we got to go through this, prohibits offshore drilling. I actually voted against this in the first committee because I didn't know where the governor was on this. And then about 3 days later, I saw him having a press conference with the Interior Secretary, Environmental Secretary. And I said, you know what? I think I need to rethink my position given I'm a gubernatorial appointee. So that amendment, amendment number 5, is also before the Supreme Court now. So it's still being challenged right now. It is on the ballot, but that could change. In addition to the offshore drilling ban, it also extends the ban of smoking in public places to vaping in public places. And so the way we bundled this was, anyone have a clue? Chris, you can't raise your hand. Air and water. We figured they went together, air and water. So that was that. Amendment number 10 is actually one that was challenged, and that I believe, if I could look at my cheat sheet here, is actually safe. That was defended by one of my colleagues, Barry Richard, in our office. Among other things, it required the retention of a Department of Veteran Affairs at the state level. It changed the dates of the legislature in the Constitution for even years to start in January. It also created an Office of Domestic Security and Counterterrorism within the Department of Law Enforcement. But the main crux of this amendment was that it basically took counties that had home rule types of charters where they did not have an elected sheriff or an elected property appraiser or tax collector, and changed it such that every county in the state will now have to have those petitions elected. There is a lag in that effective date, but to the extent this passes, that will go into effect for those home rule counties. Amendment number 11 is one that similarly is still under challenge at the Supreme Court. This bill, believe it or not, or this amendment, believe it or not, we had language called the Alien Land Law that did not allow certain foreign-born people to own property in the state. Of course, we've not been enforcing that for many years, but we took that out of the Constitution by virtue of this. We also, as Tom pointed out, there was high-speed rail language in the Constitution that really should have never been there. We took that out through this amendment as well. And lastly, and most importantly, for minimum mandatory sentences, which really are a relic of the past and something that has overcrowded our court system and judges feel they have no ability to deviate from, this provision, which I ultimately hope this does get on the ballot, and whether it passes or not is another story, but I think it would be good to get that flexibility to judges on the minimum mandatories. Amendment 12 was something that former Senate President Don Gates really felt very strongly about. It would create the most expansive lobbying law in the United States right here in the state of Florida. The law would expand the current 2-year ban on lobbying the state, if you're a state official, or the legislature, from 2 to 6 years, in addition to not being able to lobby while you are in office. And it prohibits abuse of a public position if you are an elected official. So I don't know, I've not seen any polling on that, but I'd be surprised if something like that did not pass. Lastly, Amendment 13, which got a lot of publicity. It started out as Tom Lee's proposal, and the Attorney General, because of her passion for animals, really took that over, and that was the amendment that ended dog racing. There was a ton of testimony. It was really interesting to see the dog owners bring their dogs to the hearing rooms and to some of the meetings that we had. That was challenged similar to some of the other amendments, and that ultimately is going to stay on the ballot, and so people will be able to vote on that amendment in November. And that concludes my prepared remarks. It was an honor. I didn't necessarily ask for the appointment by the governor, but it was certainly an honor to do what we did. And again, I'm not sure this process should be in place. I would say to you that if it got repealed, even though I spent about a year of my time working on this, it would not offend me in the least. But again, I go back to where we started, and from my standpoint of view, we might have some good things on the ballot, but we certainly don't have anything that would be harmful to the state or the business community, in my opinion. And so for that, I'm proud of the work we've done. And Tom, I don't know if we have time, but I'd be happy to answer any questions if we do. Yes, Gordon.
Yeah, thanks, Fred, for your service. 2 quick questions. One, on the 60% threshold you mentioned, is it 60% of the votes on the proposal or on the ballot itself? Because I can see a case where a lot of people don't make it to that part of the ballot, right? Because it's a long ballot. And then number 2, if you can, what is the most interesting proposal that you saw, i.e. craziest thing you saw that is
So it's 60% of those voting, so it's going to be very difficult to pass these. The craziest proposal.
Is it 60% on actually, people actually have to vote on the proposal, or they have a ballot where they don't vote at all on that portion? Is that count against?
Do the undervotes count against you? I don't know the answer to that. Do you know, Tom?
I do because we had a So AIF and the business community had a proposal, so
Which, by the way, was the most confusing proposal we dealt with on the floor.
we weren't confused. AIF wanted it to be,
Well, neither was I, but the rest of the commission and your sponsor was, so.
AIF, again, our approach is do no harm. So we wanted 60% of basically everybody that showed up and voted in the governor's race.
Right.
But that did not pass, so that right now, if you only have, let's say 50% of Florida registered voters come on election day or vote, and let's say only 20% of those actually make their way all the way down to number 13, conceivably, now you're left with 10% of all registered voters, and you could get 5.1% of Floridians that will change the Constitution. But that's, that's.
So it's 60% of the vote on that particular.
That's right.
So to put it in layman's terms, if 1 million people vote in the election, but only 10 people vote on Amendment 13, and 6 of those 10 vote, that will be.
Okay, that was my question. Thank you. And then craziest thing you saw.
Geez, we saw a lot of crazy stuff. I mean, we had people from all around the country emailing us late at night. I need to think about that. I mean, I will tell you there was a lot of off-the-wall types of things where people, and some of them were passionate. I mean, some of them really cared about their issue. I mean, I think the energy thing, even though it got a lot of credence, was pretty crazy to change energy policy in one fell swoop with 37 people that are spending a couple hours a week working on something. I mean, that would have been out there. But there were proposals to create a state income tax, to increase the sales tax. I mean, those types of things we saw all the time. Thank you. Anything else? Thank you, Tom.